Hello, everyone. Welcome to the second day, session number 4 of Digital June 2021. We are very happy to have you here. Most welcome to you all. We have received a great response to this conference. Over 1,200 people have registered for the conference. And that basically shows that how interesting this topic is. And with the digital economy, the most important issues are really the regulation and data issues. And those two sessions are today. So what I call this is the heart of this conference. Earlier, we had a session today on regulatory issues in different business models in digital economy. This session is about data protection and data ownership. So with us, we have today Mr. Vaibhav Parekh, who is the session chair of today's session. He is also leader of M&A, private equity, and TMT practice at Nishith Desai. On top of that, Vaibhav Parekh also leads Nishith Desai's US operations from New York office. With Vaibhav, we have 4 speakers in this area. Aaron Kamath, who is a leader of international commercial law as well as TMT practice. Ainika Charles, who is a member of TMT and IP practice. Then we have Amalan Mohanty. He is a public policy counsel with Google. And Jennifer Tiang, who is the regional cyber lead in Asia for Wilson Tower Watson. So thank you, Vaibhav, Aaron, Ainika, Amalan, and Jennifer. I look forward to your session today. Before I go forward into it, I want to thank our partner for this session, Fiki, for supporting us. Now, during this session, if you have question, please post it in the chat button, which is at the right corner at the bottom of your screen on the right side. If you are using WebEx through the browser, you will see a chat button over there. Just click on it and post your questions. And after this session is over, we are going to also have breakout session, breakout room to meet speakers. Now, during this panel discussion, you will be on the mute, so we will not be able to ask questions to speaker, but do post your question in the chat, and the session chair, depending on the availability of time, will take up your question. Just quickly, a disclaimer that the speakers have come here on their own personal capacity. So the views they are presenting and opinion they are rendering are primarily their own opinions, not necessarily those of the organization from which they come. I also want to thank a lot of our supporting partners for this conference, including Center for Digital Future, CUTS International, FICCI, IAMAI, IFA, IVCA, NASCOM, Thai Silicon Valley, US-India Business Council, and Wilson Center. In addition, we also have Brand Capital International, which is strategic investment arm of the Times Group as a media partner. So thank you again, everyone. And I hand over to Vaibhav to start the wonderful discussion. Vaibhav.
Thank you, Meher, and welcome everyone. Look forward to an engaging presentation today, since I have a great panelist with me. When you talk about privacy coming from, India, where we have so many people, where it's so dense, right? Where it's a community culture, where our neighbors know every breath we take, right? Privacy as an expectation is possibly last thing in our mind. At least that's how I have seen government approach privacy. In fact, privacy was never on the top of the agenda for a long time until there was a pressure from external, specifically from outsourcing industry. And that's where government amended the IT Act and came with rules which protected sensitive personal information, but really did not come up with any privacy law till now. Things changed when Supreme Court in their landmark judgment held that privacy is a fundamental right. And in that case, government also undertook, or kind of undertook, to come out with a comprehensive privacy regime. And I think in the last few years, the government is still working on that regime. We have seen the bill being there for some time now. But things are keeping on changing. Government is actually looking to make it even broader and cover personally identifiable information as a part of the bill, and that's something which is going to be interesting. So, from all these issues which we will see today, I want to bring out two issues which are.
Well, I'm sorry to interrupt. Yeah,
okay.
Can you be a little louder?
Let me come close to the mic and say. Now, I hope this is better. So I would want to really take two issues, mention two issues which have become somewhat controversial, and they are data localization and non-personal data. Now, data localization is, just to get everybody on the same page, data localization is a requirement where government says that either the data should not leave India, which means that it should just remain only in India, or then there is another version which says that at least one copy of data should be in India, which means that you can take the copy out, but at least one copy should be in India. And depending on how government actually comes up with what kind of data, it is going to have a major implication on business, right? To some extent, people do say that data localization is anti-globalization. If tomorrow everybody, all government starts putting data localization in place, it will be a very difficult place to do business with. And Indian government should be really cognizant of the fact and mindful of the fact that just like Indian data is being, let's say, used by, let's say, just as an example, US companies, Indian outsourcing industry, Indian software industry possibly hold a lot of data of US citizens. So, if similar situation comes where every country starts looking at data localization, our IT industry can get badly affected. So anything on data localization needs to be carefully moderated, carefully thought about, keeping in mind what exactly the implication would be going in future. The second aspect, which I think I would want to deal with, and we will deal with in this session, but I want to point out, is non-personal data. There is a reasonable expectation of privacy amongst people. But when something goes beyond data which is personally identifiable, which is non-personally identifiable data, right? Then things go beyond what is generally expected from privacy perspective. And our Indian government is actually looking at expanding the privacy law into general data law and include regulation on non-private data. Now, this is going to be a very interesting situation. I'm sure a lot of governments are thinking globally and looking at data monopoly and other stuff. But data, as economist has actually mentioned a couple of years ago in their cover page, data is like new oil, and government has kind of recognized it. Government actually wants to regulate the data from their perspective. But data also is a fuel, just like how oil is a fuel for various industries. Data also becomes a fuel for various new businesses, new economy, and specifically artificial intelligence or AI. And we believe that if government doesn't get this thing right, it can throttle the data and affect the AI industry, which a lot of other countries have taken a lead. And considering that India has the ability of a rich data set, India is in a good position to actually lead from AI perspective. So government also should be cognizant when they come up with anything on non-personal data, the implications it will have from perspective of other industries and how it can get into regulating or enabling that particular thing. But this is something which we will look into in detail. In today's session, we will cover what the current law is, what is a proposed law. We will cover non-personal data. We will cover also from practical perspective, what is the risk mitigation strategy or risk mitigation one needs to look at it from all the different regulations they need to comply with, right? How do you really manage the risk? And then we will look at what is the way forward. How is government of India looking at it from establishing the legal and what are the new developments of law which has happened, and then we will just close it with any conclusion. With this, let me first go to Ainika. Ainika, can you give what is the current law and the proposed bill? What exactly is there in the proposed bill? What are the things which you would like to tell the audience they need to keep in mind?
Thank you, Vaibhav. And a special thank you to everyone who's joined us today. It's late in India and you've joined in from all over the world, so thank you. I would like to take a few minutes to just give an overview of the current law, the proposed law, before we turn it over to our esteemed guest panelists who will give us their insights on the industry. As a first step, there are broadly two kinds of data, as Vaibhav mentioned. One, personal data that identifies an individual, which could be as simple as your name, as your email ID, as long as it identifies you, and non-personal data that doesn't identify an individual. And current data protection law in India is made up of the Information Technology Act that was introduced in 2000 and the data protection rules that were introduced in the year 2011. And this law is a much more simple law as compared to the proposed law or as compared to GDPR, as I'm sure a lot of us have been following, which applies to Indian entities. The compliance requirements under the data protection rules specifically apply only to Indian entities who process certain sensitive forms of personal data, which include financial or health or biometric data, and not all forms of personal data. And the compliance requirements that they have to follow are fairly simple. It is a consent and notice regime that all entities processing sensitive personal data in India have to currently follow. While these rules don't apply to foreign entities currently and they don't have these compliance requirements, the Information Technology Act does have limited extraterritorial applicability for certain penalties. If there's a offense that's been committed by a person outside India on a computer system located inside India, the penalties under the IT Act would apply extraterritorially, and that's the limited extent to which it applies to foreign entities. And in addition to the current general data protection law, we have to also keep in mind that there are certain sectoral data protection regulations that do come into play for regulated entities. For example, the banking or the telecom or the insurance sectors do have certain regulations that apply specifically to their regulated entities, even in the field of data protection. Moving on, there is a proposed overhaul to this current law that is currently pending in Parliament in the form of the Personal Data Protection Bill 2019. And the most recent draft that we have of the bill is from December 2019. And while we expect to see a revised draft in the coming months, I'm just going to spend a few minutes on what the current draft of this new proposed law says and what it actually means for the industry, both in India and outside India. So this law is far more complex than the current law and is very similar actually to the GDPR. So those of us who have read about the GDPR, about the kind of stringent compliance requirements, the kind of penalties that it prescribes, the proposed law would institute a very similar regime. So at the outset, in contrast to current law, which prescribes compliance requirements only for certain forms of sensitive data, this proposed law will now come in and regulate all forms of personal data. So even if you're collecting a name, an email ID, an address, you would be subject to the compliance requirements under current law. It also regulates certain forms of sensitive data and institutes a new category of data called critical personal data that will be notified by the government going forward. Another very significant change in the proposed law as compared to current law, and especially relevant to those of us who are outside India, is that this law does have explicit extraterritorial jurisdiction and will apply to foreign entities and will then impose significant compliance requirements on these foreign entities. And this extraterritorial jurisdiction kicks in three instances. One, if there is a business being carried out in India by that entity. 2, if there's a systemic activity of offering goods and services to individuals within India. And 3, in connection with any profiling of individuals that's taking place within India. The proposed law also distinguishes between 3 different kinds of entities, and their compliance requirements would accordingly differ. The first is the data fiduciary, which is the main entity who determines the purpose and the means for which the data is being processed. Second is the data processor, who processes any data on behalf of the data fiduciary. And third is a new category of data fiduciaries called significant data fiduciaries, who will be notified going forward, and on the basis of the volume of data they process, the sensitivity of the data they process, the turnover they make, to name a few considerations that will be taken into account while naming such significant fiduciaries. Also relevant is that the new proposed law proposes to introduce a new data regulator that will function as any other sectoral regulator, such as the Competition Commission of India does currently. It will be called the Data Protection Authority, or the DPA, and will be tasked mainly with enforcing the provisions of the PDP bill, which until now has not been seen before because we don't have that kind of regulator currently. So that its implementation is something that we will need to see going forward. As Weber also mentioned, data localization and cross-border transfers is a very contentious topic under the current law, where a copy of all sensitive personal data does need to be stored inside India. So this has widespread implications if foreign entities currently have not made any storage processing requirements in India. They would need to institute the same. And very quickly, a few more highlights of the proposed law is that it grants typical rights to individuals along the lines of the GDPR to access, to correct, to erase their data. It gives them a limited right to be forgotten. There's also a data breach notification requirement to individuals in certain instances. And very importantly, it does prescribe very hefty financial penalties for non-compliance, which the current law doesn't. And these financial penalties can go as high as to 4% of the global turnover of the non-conforming entity. I hope you're with me so far. I'm just going to spend a few minutes on the proposed framework for non-personal data that is currently in flux, as we will go through later in the session. In 2019, the central government had constituted a committee to examine the governance of non-personal data. That committee subsequently released reports and took industry feedback on both of them. And just as a very quick summary, the report calls for a separate governance framework to regulate forms of non-personal data, which would include certain aspects. They would put in a new regulator, a separate regulator from the DPA that would regulate only non-personal data. It would require entities to register as something called a data business, and also prescribes a very intricate model of data sharing of non-personal data by these data businesses. So thank you for your time. I'd hand it back to Webhouse.
Thank you, Ainika. Appreciate your small summary of the current law as well as the proposed bill, and also the governance of non-personal data bill. Now, this is the non-personal data is something which is very, very interesting because it possibly has one of the most significant implications for new businesses. I think most industries have come to grips with privacy aspect, and they kind of know how to manage it and create it. We will look into that in detail later. But let's go to the non-personal data, and I will go to Amlan here to you. What is your view on non-personal data and the regulation? What are the principles you believe government should look at when they deal with the non-personal data?
Sure. Thanks, Vaibhav, for the question, and thank you to NDA for having me at this event. It's a real pleasure to be here. So, Vaibhav, I think it's a really interesting question, and I'll maybe start from something you said early on in your opening remarks, which is that non-personal data is actually an evolving concept. It's a novel concept which hasn't been tested everywhere else. And therefore, it's really important for the government to get the fundamental principles right. So I just like to talk a little bit about some of these principles, as we discuss these topics with regulators, as businesses that obviously deal with data, and this is across different sectors, whether it's entertainment or healthcare. When you deal with data, you really have to understand how data operates and what properties data has. And I think that's where we should start, and that's where regulators should start in thinking about a framework for non-personal data. So I'll spend some time talking about two fundamental principles. I think data value is something that we need to think and talk about, and data ownership, which is also, I think, something that Mihir mentioned early on in his remarks. So when it comes to data value, I think the kind of framework that we need to get out of is trying to reason by analogy. And so you hear a lot about data being compared to oil or data being compared to coal. I think these analogies, while helpful, stop short of really trying to explain what data is when it comes to regulation. Because I think what we need to focus on is attributes, right? The fact that data is easily replaceable or easily transportable or durable, or that more fundamentally it's abundant and easily created and generated, unlike, say, oil or coal. So if we have to go with an analogy, I would say data is more like sunlight, right? That it needs to be harnessed and made more usable. But I still say let's move out of analogies, because we really need to focus on what it is that we're trying to do. And if you're talking about trying to promote innovation, create more competitive marketplaces, let's talk about that. Because what you'll then find is that it's actually not data that's essential. It's the idea and the execution of what you want to do with the data, which is more important. I was on a panel a couple of months ago with a bunch of startups and accelerators and really prominent VCs from India and the region, and they too agreed that this doesn't make sense in the way that the government is thinking about it right now, because we don't just want data dumps of raw data. That's not what we want. In fact, and we can speak about this later on when we talk about the impact on innovation, it could actually disincentivize innovation in India and the ability of startups to grow. So I think what's really important is to think a little bit about data value, and then think about some of the complications that arrive when you're thinking about a framework, a regulatory framework for non-personal data. So the second thing I'd like to talk about is data ownership. And here too, I think our fundamental understanding of what ownership means does not easily translate for data. You cannot just ascribe, for example, property notions in the real world to something as intangible as data. Just for example, this idea of how do you exercise or alienate a property right does not always translate well when it comes to data, because the fact is that two people can use the same piece of data simultaneously, which isn't the case with a car, for example. So I think when we think about data ownership, we really need to do some first principles based thinking about how property rights are not the right way to think about data, but we need to think about harms, right, as potential principles that we need to protect against, and maybe privacy is a potential harm that we need to protect against, and we need to think about that. And when we need to think about enablers and why we want to enable rights, for example, or innovation through the concept of ownership, we need to have a different framework in mind, but maybe not a property rights framework. And it was interesting to hear Ainika talk a little bit about the proposals, because we've been obviously reviewing this in detail, and I find that some very specific recommendations that have been made by the Chris Gopalakrishnan committee also break down when you probe them a little in detail. For example, this idea of duty of care that businesses need to have, right, towards data subjects or data principles. It's not clear what we mean by that. Duty of care has never been defined in the Indian legal context. But more importantly, I think when you try and understand duty of care in relation to something as indeterminate as a community ownership of over data, what does that even mean? How do I have a duty of care over a group of people that I cannot even identify, or that the government has not been able to identify so far? So it's an intangible abstract concept being applied to an intangible abstract concept. which I think right now makes it very clear that we're nowhere close to being able to regulate it in the way that the government is thinking about right now. So I'll just pause there, Vaibhav, in case you have any questions. Happy to take them.
Yes, in fact, I have two questions for you, Amlan. First, as I said, right, data is a fuel, and maybe I like your analogy, right? I think we need to tell government that data is not oil; it's more like sunlight, because it's available, it's green, it's regenerative, and so on and so forth. So I like your analogy of sunlight better than the oil. But data and large set of accurate data are going to be very important from businesses' perspective, specifically from AI perspective. And I was just alluding to it earlier. What is your thought? Because AI is going to be a very important technology for a lot of other businesses. So how the data is available, or how the data is trained from AI perspective, creates impacts all the other businesses to large extent. That impacts also the competitiveness of a country, right? Because if China or some other countries have a lot of data available and which the businesses can use, their products will be much better than what, let's say, our products will be. Now, how do you think? What is your thought process on government's policy, or what how it will affect the business, specifically keeping AI in mind, and what businesses should do?
Yeah, no, great question, Vaibhav. And I think that's the heart of what we should be discussing, right? Which is, how do we think about a framework for non-personal data to enable innovation? We should be thinking about it in terms of actually creating enablers for the economy, rather than trying to chase some kind of intangible or abstract goal. So I think with that as a kind of a North Star, right? Let's break down some of what we just discussed. The proposal or the recommendation that's often thrown about in order to promote innovation or competitiveness is this idea of data sharing. And to take that further, what's being proposed right now is a mandatory data sharing framework, right? A forced data sharing framework, which I'm sorry to say, it just fundamentally does not make sense given where we are right now. And I'm talking about the Indian economy in terms of, let's say, something as simple as digitization, right? For businesses to be able to share data, there is a fundamental necessity for data to be available. And it's not just any type of data. This data needs to be high quality, it needs to be reliable, it needs to be clearly annotated. And why all of this is important is exactly for the reason you mentioned. We're operating in an AI heavy infrastructure ecosystem. And if the data is of low quality, if it is of different standards, if it is, in some way has some potential biases, your output is also going to have all of those flaws. So I think to go back to this point about data sharing, I think this regulatory recommendation for a mandatory data sharing is actually not the right way to proceed. Right? We need to, I think a little bit about what are the fundamental building blocks for a data economy, and that is high quality data, reliable data sharing infrastructure, and adequate incentives in place. So actually, when you break this down, what you'll find is that a voluntary incentive-based data sharing framework is actually the right approach for India. You spoke a little bit about what this means for our global competitiveness. Think about a mandatory data sharing framework in which we haven't addressed fundamental intellectual property rights issues. Right? When you have a database that's been created, not just sweat of the brow, but there is originality in selection and arrangement of that data, and you're being forced to share that data with another business, you can imagine why this could be a disincentive for foreign direct investment. You can imagine why startups tomorrow in India are going to think, I'm not sure if India is the right place to set up incorporate business. I'd rather go to Singapore, but there is a more reliable regulatory framework in place for a data-driven business like mine. You can see why, in the absence of any strong accountability frameworks and an upcoming privacy law, which is still not entirely clear, startups and businesses are going to be worried about potential legal exposure when they share data with somebody else, right? So I think what's really important is to keep in mind what that end policy objective is. And if it is about increasing competitiveness, about making India a global hub for data and for AI, I think let's look at what the state of the art is, right? I think let's break away some of the misconceptions. The fact that we need more data to make an AI system work better is fundamentally wrong. In fact, companies like Google and Apple and Facebook are trying to create more powerful AI systems with lesser data. That's the trend that we're seeing in terms of where technology is headed. So to just assume that more data in the ecosystem is going to make India an AI powerhouse is fundamentally flawed. I'll just stop there.
Thank you. I think your message is loud and clear, and I agree with you completely. That whenever Indian government is looking to regulate non-personal data, they need to be very careful. It has implication much beyond what they currently can see. It will have a very long-term implication on businesses where they can't currently imagine which happened, and hence they need to tread carefully with trying to be, while trying to create enabling mechanism, but not regulating it or throttling it, which creates a problem for people to use the data to really come up, with newer, better technology. But with this, maybe Amlan, I will just ask you one more question, and I'm not sure whether you can answer it, but if you can answer it, I would love your answer. The way all major business models, which we saw, were advertising-driven business models, right? Which used people's data to advertise and earn revenue. Now that model, is it going fundamental change after the privacy law and the non-personal data law, which is coming in? And if that change happens, will the services which a lot of companies are giving free because they are getting data in return and they're earning advertisement, right? Will that change and they will start charging for the services they provide? How do you see that evolution happening from data businesses? And again, if you can only answer them, you can answer. I can understand.
Again, great question, Vaibhav. I'll keep this one short. I think the short answer is we don't know, but I'm actually excited to see not only what new business models will arise, but how businesses will substitute data with other types of assets, right? There's a really interesting, I think, experiment that's happening right now on synthetic data sets, where because of some of the privacy related issues, companies are operating, for example, self-driving autonomous cars on the road and doing pilots on synthetic data sets, because you might be able to observe that data, you might be able to modulate that data in ways that you cannot do with poor quality data sets from the real world. Right? Second is the move from personalized targeted advertising to more aggregated inferred data related advertising or contextual advertising, where you're not really trying to target it at one individual, but perhaps a group of individuals or based on what that search term is. So I think there is going to be a movement and evolution in business models. There's going to be an evolution in technology. There's going to be an evolution in terms of the fundamental inputs that businesses use to be able to provide value to their users. So I'm really excited to see what happens.
Thank you. Even I'm excited. We are living in an exciting time, and we will see exciting new things happening. A lot of things is something which we have not thought of at this point of time, and that's exactly how we make our life exciting. But thank you, Amlan. Thank you for sharing your thoughts, and it's been very, very valuable. Now I will change tact and coming from simply coming from perspective of concept and principles. Let me go to the nut and bolt, right? And see, in current situation, right? There are companies which collect data, which own data. There are a lot of obligations which are kind of thrown on them. The responsibilities are increasing, the risks are increasing, and how do they manage the risk, right? Also, a lot of laws, as Zainika was mentioning earlier, a lot of laws are actually territorial in nature, and in situations like that, what kind of liability they need to be worried about, right? And how they can manage that liability is something which I would like to know. And maybe Jennifer, since I will ask this question to you, but since you have insurance background, you can also give view from insurance perspective, right? How do companies manage, do the risk management, manage the liability, and what advice would you give them on the best way for them to manage and do the risk management?
Yeah, thanks. And it is shifting gears. I could listen to Amlan a lot more, thinking about these exciting, new frontiers. But to bring us back down to earth, back to the business side of things, the risk management side. I think the trends that we've seen across Asia and in India is reflective of it. It's the same trend, aligning towards the more strict data protection laws. So from the risk management side, the changes and trends that we've seen from our clients is of course reaching out to their legal advisors such as NDA. There is a real focus on needing to understand fully the legal implications related to these new data privacy laws. And in same, this will have an effect on their risk management frameworks. And so what we've seen is a real priority given to the operational integrity around the way they've stored, processed, and accessed sensitive data. So I think prior to this, I think the whole data privacy movement has originated from the States with their very, very strict legal frameworks. And in Asia, speaking to my global colleagues, they can see that the focus on this is somewhat behind. I think it's been less regulated, and so with the trends moving towards more of a US like or EU GDPR like legal framework with revenue-based fines, mandatory reporting obligations, this has really really made businesses in Asia jump, and so there is a lot more focus on documentation, procedures, assigning ownership to individuals. So the focus has definitely been around policies, formalizing things. In the past, it might have been a bit of we're just using a kind of template policy that we've downloaded from the net, and now it's a lot more bespoke. They're investing the time. Even in terms of a corporate structure, we're seeing new roles created at C-suite level, and that's not even just for the large clients that we have. This is for medium-sized as well. So you've got roles like data privacy officers, chief data officer, chief information security officer, and these are all part of the C-suite now. So previously there might not have been that direct audience with the CEO or the board. And now, because of this whole renewed focus on their obligations around data privacy, you have the data privacy officer have frequent interactions with the board, and the elevation of data privacy on boards' risk registers has really been seen across all sectors, which has been quite interesting, not just the regulated ones like financial institutions, healthcare, even large conglomerates that have a lot of employee data, they're also having this focus on their data privacy obligations. So that's been very interesting. So I think if you think about the documentation and policies, this makes sense from a risk management perspective, because you always think of, what's the worst that can happen. And so in the event they're met with a regulatory investigation, they'll need to show that they've taken due diligence, all reasonable steps to prevent that. And so then they work backwards from that, and they need to have a paper trail and evidence of the fact that they've taken all due care to prevent this data breach from occurring, or this cyber attack that has manifested in a data exfiltration happening. So yeah, a lot of more paperwork for IT teams. We also see a lot more cross-team collaboration. So you can't. It's not just the IT teams working in silo. There's a lot of, cross-pollination and cross-collaboration across teams. IT with legal, with risk managers. So that's been interesting, and it just shows how data privacy and other cyber-related risks really cut across all spheres of the business. And you did ask about the insurance, which is a necessary part of risk management. So I'll cover the insurance. The two key themes, the two key concerns that have arisen from our clients when they've been considering the implications of these new, more stringent data privacy laws is the revenue-based fines. So if you think 4% of a total revenue, that would be a significant figure. And the mandatory reporting obligations. So I'll take in terms of that first one, the fines associated with non-compliance of data protection laws. That has been a real driver behind companies considering cybersecurity insurance. There is potential cover for data privacy related fines, although we're yet to see, and we're yet to see how the bill in India is manifested on this point, whether fines are going to be permitted to be covered by insurance. It's been a hot button issue for all insurers and legal commentators whether these fines are insurable. So in the insurance policy, the best we can really do is negotiate broad language to the effect of fines will be insurable where legally permitted, or something along those lines. The issue still hasn't been tested at court, so this is something that we're eagerly waiting to see whether case law will be set in the future. And then the second arm, or the second theme that has been very key, is that mandatory reporting obligation following a significant data breach. So if you think about the costs that could be incurred, legal costs primarily, and notification costs related to a data breach, these can be really significant, especially when you're on the clock. So if a data breach happens, let's say you've got 48 or 72 hours to report it to the regulator in a prescribed form, the urgency around that action, the cost involved in those steps that you need to take can be very significant. So I believe this is a reason why many companies have been turning to insurance to see how they can offset those financial costs. Oh, I think you're on mute.
No, we can't hear you.
Okay, is this better?
Oh, much better. Yes,
Okay,
yes, yes.
awesome.
Even better than before, Weibo.
Oh, thank you. So thank you, Jennifer. Thank you for your practical advice on how do you manage the risk. And also, I know you covered it to some extent, but also if you can tell, because you work a lot with companies who comply with GDPR, and you have seen how the compliance issues which arise, and considering that Indian proposed law also is in lines of GDPR and how it is going to go towards. Is there anything additional any piece of advice you want to give to the companies in India, what they need to be facing when they're doing business in India? Whether they are non-Indian companies doing business in India, or the Indian companies who have not complied with GDPR before, but they are now going to comply with Indian proposed law. Any words of wisdom you have on that? What additional thoughts you have on this?
Yeah, for sure. And Inika touched on it earlier, that concept of extraterritoriality. So I think this is something that a lot of the companies, in Asia and India, they may be unwittingly subject to data privacy laws of a country that they think, we're not established there, or we don't process data there, but under the concept of extraterritoriality of these laws, they may fall under the the legal arm reach, and it just goes to show. Amlin mentioned it earlier, the amorphous and intangible nature of data. Like the risks associated, it's borderless, intangible, and so I think it can't be understated. There really needs to be a clear understanding or mapping out of where their data obligations and duties lie. So it necessarily involves, all business units discussing together, like from a practical perspective, our operations. The one example that comes to mind is a large conglomerate of ours, and if you can imagine, there are real patchwork of different IT teams and different systems and networks. And so for them to really have one clear view, a centralized viewpoint of where their data obligations are across, across jurisdictions, across regions, it really took a lot of time and a lot of workshopping to truly understand where their obligations started and finished, and the involvement of many third-party service providers, a lot of cloud infrastructure or hybrid cloud infrastructure. I think this adds complexities around the idea of what are we responsible for, what do we own, and so there is no shortcut or fast way around it, unfortunately, but it does involving all the relevant business units. It's not just the data privacy obligations. IT kind of look after our data and we leave them to it. You can't approach it in that way. So yeah, no shortcuts, unfortunately.
Yeah, thank you, Jennifer. I agree with you. Life problem to solve much later on. That's my belief in life too.
Yeah.
Do it first time, right? Let's come to the next part of what I want to discuss, right? Which is how is India? What next? Right? What happened? Whether it is in courts, case laws, or something, new regulations which have come in recently. And Aaron, can you give light on?
Okay, I think there's an issue with Webav's audio, but I understood the gist of his question, and I understand we're just past 10 p.m. here in India at least, and we'll try and wrap up in the next 10 minutes or so. But just looking in terms of what has happened in terms of developments and what we can look forward to in terms of privacy regulation in India, it's important to understand what's happened in the last year or two and how it may shape the regulation going forward. For instance, we spoke about the proposed data protection bill that was introduced, at least the last version that we have was introduced in December of 2019. But in that year and a half, a lot has happened. The context in which the bill was proposed has now changed. Of course, we've had a pandemic, we've had changes, we've also had technological considerations to keep in mind. And a lot of these developments, some on the regulatory side, some on the judicial side, of course, some on the industry side, would seem to change the way regulation is shaping out and what may ultimately come out in terms of the proposed law. So just marginally looking over our shoulders over the past few months, we've had various regulatory updates. For instance, the Bureau of Indian Standards has issued an independent set of data privacy assurances, which is the IS 17428. This is essentially a privacy assurance framework for organizations to establish, implement, and maintain in order to improve their data privacy management systems. It's a certification for organizations to assure both their employees, to assure their customers that privacy and data privacy practices are implemented effectively, and they can use that as a differentiator among some of their competitors. Why that's relevant is today we have the IS 27001 standard, but this being another standard, it could have a play out in how regulation, the privacy regulation terms pans out, and if at all it incorporates this BIS standard or makes reference to this BIS standard as a benchmark going forward. In terms of sectoral regulation, and we spoke, in some extent on the insurance sector, we look at banking, for instance, the Reserve Bank of India, other regulators continue to regulate their respective industries. The RBI, for instance, even as 3-4 months ago, clarified its position that payment aggregators and merchants shouldn't store cardholder data going forward. And that's also a data-related consideration for the industry. In terms of judicial developments, we've had ever since the pandemic that hit well over a year ago, we've had initially during the first wave in India, we've had state governments engaging technology service providers, and in a couple of instances, non-Indian technology service providers, such as one based in the US. So this went to the Kerala High Court, and the Kerala High Court exercised judicial activism and elaborated on the sharing of data and how certain measures were not enforced, and actually set out guidelines for sharing of sensitive data of patients, for instance, with technology service providers, and that anonymized data can be shared. Non-anonymized data shouldn't be shared, especially with technology service providers outside India. It asked for the data to be anonymized. It asked for unanonymized data to be returned back into India. And it also specifically set out that the technology service provider couldn't commercialize or advertise its relationship with the state government arising out of its arrangement for the COVID-19 diagnosis and treatment. We have things like the WhatsApp privacy case, which is currently pending before the Delhi High Court, and we are monitoring developments unfold on that. We've had high courts in various instances emphasize that today individuals do not have a fair set of personal rights with respect to that data, and they should, in some cases, especially in domestic violence cases, in domestic disputes, have a limited sense of a right to be forgotten. So this is all, in a nutshell, how things have panned out in the last year and a half and how it may shape the regulation going forward. In terms of the proposed regulation, of course, we have probably what may be a data protection bill, and something which we understand that may be tabled before the parliament, may be introduced by the Joint Parliamentary Committee in the upcoming parliament session, which should ideally begin in July. At least historically, it generally begins in July and goes through till September. We understand that the GPC, the Joint Parliamentary Committee that has been studying this, has had nearly 70 sittings, 70 meetings relating to various aspects of the bill, and there are nearly 90 amendments as compared to the bill that we have from December in 2019. So we are expecting some traction on the proposed law. Of course, we do have to keep timelines and the government prioritization of efforts once we ride out the second wave of the pandemic. So we also have to keep that in mind. But there is a good chance we could see a revised version, a more crystallized version of the bill in the upcoming months. In terms of the interplay between non-personal data and personal data, that's of course the million-dollar question, and how that's going to be regulated. And I completely echo the panelists before me that thought has to be given to both independent regimes and what exactly the government wants to do and how exactly is the best way to do it. There were certain insights which were floated that the data protection bill would initially be expanded to include both personal data and non-personal data. From further updates that we have, we now do believe that it may be just a personal data protection bill, and there may be independent policy that may be released for non-personal data. But of course, we'll have to wait and watch how the two independent but yet parallel regimes on personal data and non-personal data, how they ultimately pan out, and the interplay between both of them. So we have a lot to look forward to this year and a lot to keep us busy. And thank you, and back to you, Vaibhav.
Okay, while Vaibhav is coming on board, I would like to take this opportunity to ask panelists to ask any other questions you have with each other. Okay, if you don't have that, then I will ask one question. We talked about different type of data, right? Personal data, sensitive personal data, transactional data, community data, or non-personal data, machine data. When you look at all this data, what do you think, how this data should be managed? Do we need to have different guidelines for all this data? Do we need to have, one overall framework for this data? What are your thoughts on this? Amalan, Jennifer, Aaron, Ainika, you heard me, right?
Yeah, I can take a quick stab at that. So I would say what we shouldn't do is treat all data types as homogeneous and treat them all the same way, which is what we're seeing, obviously, in the proposals that are coming out of India. You'll see now over, I think, a period of time, there's been some evolution in that thinking, where even non-personal data, they're trying to break down into different data types. There's actually now been a strong lobby advocating to separate non-personal data that relates to humans and non-personal data that relates to machines. And I think those are the types of conversations we needed to have even before the government proposed any regulation of non-personal data. So I think, just to summarize, let's not treat them as homogeneous, and let's ask for more granularity even in the supersets of data that we've been talking about so far, right? So break down personal data into multiple types. Let's break down anonymous and aggregated data sets into different types, and let's certainly break down non-personal data into different types and treat them separately.
Anika, Aaron,
Yeah.
Jennifer, any other comments?
Hey, sorry, I think I shut the video off, just trying to make sure if I can get my voice out, that would be great. Thank you so much on that. There is one question, and I know we are running out of time, but there is one question which is coming, if I can quickly take it up. The question is, could the new initiative by government for doing away with tolls instead of tracking vehicular location to charge for tolls lead to backdoor for invasive surveillance, right? I think the question really, when somebody looks at privacy, always the concept of surveillance becomes relevant, and I think that's a question. Is there anyone who wants to take that question up on surveillance? Okay, let me answer that question. So I don't think simply by tracking the vehicles you can really have invasive surveillance. Again, it depends on how the technology is actually used. But at least my understanding is that just because, anyway, when a car goes by, the information is recorded which car is going by and what toll they are paying, and just simply by having it done automatically using a cashless method does not, in my mind, increase any additional surveillance than what it currently is. So that actually is a short answer, but happy to answer it more in the breakout session. With this, we are out of time, and thank you all the speakers for fantastic session and answers from your side, sharing your thoughts and giving practical advice. So thank you once again, and sorry about my technical issue. Something went wrong somewhere. Apologies for that. With this, Meher, I hand over to you.
Thank you, Vaibhav, for the wonderful panel and a great discussion. We are all on the far ends of the world everywhere. It's so good to have you all here, without spending much on the carbon side. So it's really always good. So I want to thank Vaibhav, who is in New York, Aaron and Anika, who are in Bangalore. Amlan, I believe you are also in US or in and Jennifer, you are in Bangalore too, right? So, and Jennifer, so thank you so much. It's a very fascinating topic, given that there are so many different types of data, and how do we grapple around this data? And as Amlan mentioned, that data, is it really an oil or is it a sunshine, right? It's very interesting analogy. Everybody talks about oil, but maybe it's more like a sunshine, where you don't use it, you lose it, and it's perishable. So I think this was a great panel. Tomorrow we have another 2 sessions. Again, very interesting discussion. We have great experts looking at the antitrust issues, because all these big techs are certainly getting that attention from regulator about competitive behavior. So antitrust, entire session on antitrust and competition law issue. And then another session is also an area which is you don't really find at a lot of conferences, which is looking at tax issues. You find the tax specific conferences, but you don't find general discussion about tax in digital economy. And it's going to be, again, a big issue, given that the entire economy is shifting towards digital economy. So government wants to, at the end of the day, get a piece of it. So you will see tax becoming a big issue, and that's another discussion we have today. Now, today, for this session, we have applied for CLE, MCLE credit with the State Bar of California, as well as in New York. So if you are interested in receiving the credit, MCLE credit for this, please write to linate.h@nishithdesai.com. That information is also available on our website, www.digitaljune.com. What is not available is this code, which you need to use to get the credit. And the code is 94301. Again, 94301. So with this, we come to the end of this session. You can meet speakers in a breakout room, which for every speaker, we have a separate breakout room. So go, you can discuss with them questions you have and the comments you have. And I look forward to seeing you tomorrow again at Digital June 2021. Thank you again. Thank you all the speakers, and thank you all the partner organization for your support. Take care. Bye-bye.
Thank you, everyone. Bye-bye.